Okay. So imagine this. You own a house. Yeah, given the economy right now, like probably seems like a fantasy, but imagine for a moment that you own a house and your neighbor wants to build a huge pool that goes into your yard as well. Of course, you're probably allowed to use the pool once in a while, but ultimately the pool is still in on your property. How would you feel? You know. So this is basically what happened to the Blueberry Rivers First Nation just a few years ago. So this case, Death by a Thousand Cuts, it's a case study on the cumulative effect that happened to the Blueberry Rivers First Nation, and the case was brought up in Yahey v. British Columbia. Yahey is the name of the chief, or the last names of the chief of Blueberry Rivers First Nation. Okay, so what are we going over today? We're going over the background and summary. So, introduction to the case, what is it? Where did it come from? And we'll move on to the significance of this case. So, why is this case significant to Blueberry River First Nation? Why did it make such a big splash? Anticipated impact. So, externally and internally, what are some impacts that came from this case? Indigenous participation. So, how did participation from Blueberry River First Nation affect the case? And yeah, how did they change the course of the development and the case? And lastly, we have findings. So, we're going to go over the Indigenous perspective as well as the perspective of the Crown regarding this case, anyways. So, background and summary. Introduction. So, why is this a groundbreaking case? Blueberry Rivers First Nations, we're going to call them Blueberry, won the case against BC in Yahey v. British Columbia. So the province was found guilty of breaching Treaty 8 rights. So it was found that because of developments of cumulative impact, the people of Blueberry could not meaningful exercise their rights to hunt, trap, fish, and maintain their way of life. So yeah, that's what Death by the Thousand Cuts refers to. It's a cumulative effect since 1906. So since way back when development started back to back to back, and it piles up. So now it's affecting heavily on Blueberry River First Nations. So approval for logging, oil and gas development, dams and mining, all that good stuff. So what is the conclusion? It was concluded that the province allowed for extensive development without assessing cumulative impact. So yeah, and therefore violating treaty obligations. Simple as that. So what is Treaty 8? It was is a treaty encompassing a larger area in BC, in northern BC. It was signed in 1899 at Lesser Slave Lake, put into effect in 1900 at Fort St. John. So yeah, the territory encompasses up there. Anyways, when it was put into effect, the treaty included the rights to hunt, trap, and fish for indigenous people living in that territory. And yeah, so there was a section, it said that the treaty may be subject to change for settlement, mining, lumbering, trading, or other purposes, which basically means that the crown may take up some land here and there from time to time within reason to put up development. And yeah, within reason is the key word here. So yeah, Treaty 8 region encompasses the Upper Peace region in northern BC. So Blueberry River First Nation is a nation within that whole treaty. So it included many nations. Blueberry is one of them. So it includes the Montney Basin as well, which is a huge reserve for oil and gas exploration and extraction. So it's yeah, there's a lot of resources up there that are up for grabs, but yeah. And it also includes the Site C dammed as a forestry, mining, and agriculture sites as well. So yeah, here we have the original Treaty 8 document photographed. I also included a link in case you are interested. It's a very interesting website overall. Yeah, so here we have the Treaty 8 area. So you can see it includes a lot of northern or northeast BC, as well as a bit of Alberta and Northwest Territories. So what is the significance of this case? We're gonna do an external analysis on the significance. So going over each factors, and we're going over how each external factor comes into play. So politically speaking, BC's prove it approach has been controversial because it forces First Nations to go to court. It's a deflection tactic that makes them go around a bunch of obstacles if they wanted to make change. Economically speaking, new development and selling of licenses are always happening. And yes, people want development, but it has to be done sustainably, not irresponsibly. And yeah, existing developments, like machineries, buildings, and such, they are already in place, and it was expensive to put them in place, also very expensive to take them out of their ecosystem. So how does that affect this case at all? And yet, social and the cultural aspect of this external analysis is the relationships between the indigenous communities and the crown. It's always been roller coaster. So how does that play into this case, considering all the um, treaty obligations and Section 35 of the Constitution? So the environment surrounding this area is, yeah, up to 85% of area within this region are within 250 meters of development disturbance, and up to 91% are within 500 meters of development. So this left the people of Blueberry without meaningful rights to exercise their hunting, trapping, fish, etc. Legally speaking, BC promised to include or incorporate UNDRIP into the legislation in 2019. How will they do that? It's still a question. But ultimately, the province still makes the decisions unilaterally, which means that despite all the consultations and such, they are ultimately hold the decision-making power. So why is this significance to the case? So as I've said before, um, the province proved its approach forces indigenous nations to go to court. This poses problems because of resources and funding. A lot of First Nations do not have adequate funding, so this poses a challenge, an obstacle for them. So, for example, this case, it took 6 years, over 160 days a trial between 2019 and 2020. So it required a lot of commitment and energy. Yeah, so it was hard for sure. Economically speaking, existing developments are not going to be terminated because, like I said before, it's extremely expensive to move them from the area. So if you navigate to the Blueberry River First Nation website, which is cited at the end of this presentation, you can see that they've reached an argument, or not an argument, reached a decision to um, work around the existing development, so how to maintain it sustainably, but it will not be terminated. And some pre-approved projects will still go ahead, but of course they will have to be done sustainably. And yes, socially and culturally speaking, will this mean a strengthened relationship between BC and Blueberry? Maybe, because now that Blueberry is has won the case, BC is under direct obligation to make sure that everything goes smoothly and sustainably as well. And of course, respect for treaty rights. Environmentally, impacts left Blueberry without meaningful rights to maintain way of life. This will have to change because this was the driving force behind the case. This is how Blueberry was able to win the case. So, as I will address later, Declaration 3 and 4 really make this case. And finally, legally speaking, BC will be required to work with Blueberry to incorporate UNDRIP as in the 2019 promise. So, will this mean future EIAs will incorporate indigenous-led impact assessment? Probably for Blueberry. As for other nations, that is still unclear. This could be a precedent, though. So, what are some anticipated impacts, both externally and internally? So, yeah, as we've mentioned before, the crown pivot approach, we've mentioned it a lot of times because it is such a prominent problem, deflection tactic that makes indigenous communities, go through all these obstacles. So, after this case, it really highlights the province's delay and deflection tactics so that it's much harder for indigenous communities to make change. Also illustrates the necessity to implement UNDRIP. So what does that include? It includes the indigenous rights to protect and conserve their territories, informed consent, not implied consent, as well as the key aspect, the key takeaway from this case is to take action proactively. So Blueberry River First Nation saw the cumulative effect, and they went to court to bring this up and not just not attack, but mention one case at a time. Is a cumulative effect. And yes, Blueberry and BC reached an agreement just early this year, which is very exciting. The partnership will ensure that the Treaty 8 rights will be respected. The province is putting $200 million of restoration fund by 2025. They will also incorporate an ecosystem-based approach on land use planning. So that means that they will first and foremost consider the impact on the land when planning developments and such. There will be a limit on petroleum and natural gas, or PNG. That means land protection, so more than 650,000 hectares of land will be protected from PNG or forestry activities. BC and Blueberry will reach a wildlife co-management effort, which will support land healing and population recovery of moose and other species affected by developments. And yeah, Blueberry will also receive $87.5 million over the next 3 years in installments, and also an opportunity to increase their benefits on PNG revenues over the next 2 years as well. So yeah, this is good news. Overall, this is good news. So now we're going to be talking about indigenous participation. What are the timeline and impact of indigenous participation? So it started in March 2015. The people of Blueberry filed a case against the province due to the cumulative impacts. So allegations that the province authorized all these oil and gas, forestry, mining, hydro road infrastructures, all that jazz on the screen right now. Yeah, so all these factors really built up a huge injury to their land, which is understandable why they would be unhappy with this development. So June 2015, they filed an injunction to halt timber sale licenses auction while the case is underway. Of course, it was denied by Justice Smith because his reasoning was that this was a project by project basis, and it needs to be more wide-ranging. So because this is a cumulative impact case, injunction on a project by project basis is inconvenience, is basically what it is. So August of next year, the second injunction was filed to halt development in general. So basically, due to what they asked before, it's going to be more wide-ranging, not project by project. Also dismissed in May 2017, basis of inconvenience, whatever that means. So a study done, I've linked the study done here. 82% of injunctions filed by indigenous communities are denied. So very unfortunate and unfair too. So yes, by June of 20, oh goodness, sorry. Yeah, by June of 2021, Blueberry River First Nation won case against BC, which is very exciting. So in Yahey v. British Columbia, the BC Supreme Court finds the province allowed for extensive development without assessing cumulative impact, which we've covered before, therefore violating treaty obligations. It was an important date. Of course, at this point in time, through all these hoops, the province may still appeal. But fortunately, in July, BC released a statement saying that the province will not appeal, which is a step towards reconciliation. Yeah, so Blueberry actually urged BC publicly to not appeal as a step towards reconciliation and respect for treaty rights, which the province agreed to. And yes, I've also included a timeline here. So between like the two ends of the timeline is a 6 years time period, which is an insane period for a case like this. So what are the findings of this case? Yeah, so what did the province take away from this case? In November 25th of 2021, yeah, forgot to add the here. The BC, the province, amended the Interpretation Act. So what is the Interpretation Act? It says that most provincial laws will be required to be interpreted consistently with the Section 35 of the Constitution as well as UNDRIP, as they promised to incorporate in 2019. And Premier David Eby, the Premier of BC, released a statement saying that they preferred negotiation over litigation. So to reach a partnership between the province and territories is very important. Yeah. So from an indigenous perspective, I navigated onto the Blueberry River First Nation website, and what they saw this case as was early partnership were forged between the Crown and the First People. However, this partnership was eroded by colonial and paternalistic policies enacted into law. So these laws require them to jump through hoops to make meaningful change on their land that are being affected by these laws. And they use these treaties as a way to protect themselves, the indigenous nations, from these laws and development. So yeah, treaties are used to advance reconciliation at this point, and as well as forming a partnership between the province and First Nations to share the land. So what are the implications for Blueberry River First Nation? Sorry, so an article or a journal entry by the law firm Osler mentioned that there could be a veto power to this case. So a summary of Justice Emily Burke's Declaration number 3 and 4 that she granted Blueberry. Number 3 is that BC may not continue to authorize activities infringing on treaty rights including honorable and fiduciary obligations. Declaration number four is that BC and Blueberry must consult and negotiate to timely assess, manage cumulative impacts, and ensuring constitutional rights are respected. So in how could be interpreted is that any potential development in the area may need Blueberry's consent. If this is the case in the court of law, this is a huge deal because that part of the province, as previously mentioned, is a hub of resource, and if Blueberry, a First Nation, has this power to mediate these resources, it would mean a lot for future development and land use planning. And this they're leading a precedent for other nations as well. So in Alberta, the Duncan First Nation, and similarly, they're filing a case, or they filed a case on cumulative impacts, very similarly to this case, and other nations may follow. Only time will tell, because the case was filed in 2022, and this case has taken 6 years. So hopefully, Duncan First Nation in Alberta will not be taking 6 years for this case to be um, hopefully won. But anyways, only time will tell. So yeah, that's everything that I have for this presentation. And here are the references I used. Yeah, I would recommend checking them out. They were a very interesting read. Thank you.